Did you know if you waive your right to remain silent and make a statement, only part of your statement will be used against you? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Okay, so I thought they had to use the entire statement, but you're saying they can just pick parts out of it?
Right. I mean, it really is a situation where you shouldn't ever make a statement because you're intending to explain your situation and give the whole story, but the prosecutor's only going to use the parts of your story that look bad for you and take those statements that you made out of context.
Wow, that's definitely not, that doesn't sound like it's in your best interest at all, as of course it wouldn't be. So what's an example of this happening?
Well, I had a case go to trial where my client was charged with a felony possession and a possession with intent to distribute. And he made a statement. He had a large amount of cash, $4,000, that he was carrying in his wallet, and he had a felony amount of drugs that was tucked in the seat of the pickup he borrowed from a friend to move. And so when law enforcement made contact with him and asked him for permission to search the vehicle, they found a large amount of drugs, and then he had the $4,000 cash on him. So they assumed that he was selling drugs and that the cash he had was basically the profit of selling drugs. But there was a whole nother story.
So it sounds like, I mean, from at face value, from the police's point of view, that looks like what's going on. But then he begins to explain, and what did he explain was really going on?
Right, so the officer asked if the cash was his. He admitted it was his. They asked where the drugs came from. He said he didn't know. And so the prosecution's theory was, well, he's lying about not knowing that the drugs are there, and he admitted the cash is his, but he also explained the reason he had the cash was because he was moving into town, he sold a lot of his belongings, and he needed the first month's rent and the last month's rent and a deposit in order to rent an apartment. And so he got the cash from selling some of his personal belongings and withdrawing cash out of his checking account.
That is a perfectly reasonable, logical explanation. So he says all this to the police, and they make a recording of this. But you said earlier, the jury doesn't necessarily hear that whole recording.
Right. And so the prosecutor basically edited the video, the body camera footage, and only included the parts that made him look bad and not his entire statement.
Okay, but you as his attorney knew that there was more to this story. So did you get it told somehow?
I was able to get the rest of his statement put into evidence. It took some maneuvering and definitely the prosecutor objecting, but I did get the other parts of his statement before the jury. That's not always going to happen, and sometimes your client's going to have to waive his right to remain silent and take the stand and then face a cross-examination that maybe points out a history of having prior drug convictions or something like that, that, isn't really going to let the jury just consider what happened in this particular case.
Okay, so the moral of the story here really is that every person who finds himself in a situation like this one did needs a lawyer's help, because this is too complicated for the average person. So how might they get a hold of you for that?
We'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.